My topic is Sharia, international law, and judicial interpretations in Pakistan. So basically, I have to focus on not on what is Sharia and what is international law, and obviously I have to speak about how the judicial interpretations in Pakistan has impacted Sharia, international law, and the society at large. In fact, what has been the response of the judicial side with regard to Sharia and international law at the same time? Because while the interpretation is a very, very tricky job, and while interpreting a statute, the constitution, your job is the creation of the law, the making of the law. Judges do make law, and the tool which they utilize for the making of the law is the interpretation of the law. This is the very basic aspect. But in Pakistan, if we trace out the judicial history of Pakistan, one comes to the conclusion that there are essentially three phases of judicial interpretation as far as the Sharia is concerned. First phase is the resistance to the Sharia. The courts in Pakistan, right from the creation to the establishment of the first constitution of 1956 and the era of Justice Munir and the famous Doso case, wherein the doctrine of necessity was incorporated in the judicial system of Pakistan. This was the era before the year 1972, from 1947 to the 1972, because the Constitution of Pakistan, that was 1962 Constitution, second Constitution, that was secular in nature. Although the amendments were introduced after the public outcry and the pressure that the Islam and the laws in Pakistan would be translated in accordance with the injunctions of Holy Quran and Sunnah. But that period is the resistance about the use of Sharia and the Islamic principles or the Islamic jurisprudence in the judicial pronouncements. No aid whatsoever about the judicial interpretation of the laws or the fundamental rights that were not allowed under the Pakistani system. You cannot employ. There was a case and in which Justice Munir spoke very harshly about a judge who basically, there was a criminal case, and I agree with his observation in that regard. There were 6 accused persons, and those 6 accused persons, the criminal case was decided on the basis of oath on the Holy Quran. So basically, that is not a good practice to decide the cases on the basis of Holy Quran. But when the case eventually come up to the Supreme Court of Pakistan, Justice Munir, instead of correcting that illegality, Justice Munir very harshly remarked about the judge, the conduct of the judge, and said that he should not be a part of the judicial system of Pakistan, because the judge does not understand that under the Pakistani law, and there was the judgment which was developed that we cannot interpret the laws on the basis of the doctrines of the Sharia. So Sharia was alien as far as the period prior to 1972 is concerned. But there was a need for introduction of doctrines of Sharia and the objective resolutions in the judicial system of Pakistan for the interpretation of the, what was the reason? There was a case which is known as Asma Jilani's case. This is PLD 72 Supreme Court. In Asma Jilani's case, for the first time in the history of Pakistan, Justice Hamudur Rahman came up with the idea that objective resolution, that is the good norm of Pakistan. Because earlier the good norm was identified by Justice Munir as the law of necessity of the Hans-Kelsen. And that theory was adopted from the, obviously, from the Western law and under the Act of 1935. And obviously, the judiciary which we inherited from the colonial era was that there was no need for Sharia in their eyes. But Asma Jilani case was the breaking through, which made the breakthrough in the judicial history of Pakistan. And they, in order to undo the law of necessity, they came up with the idea that if at all, that was basically Justice Hamood Rahman did not exactly incorporate the objective resolution, but he gave the idea that if at all there is a ground norm, that would be the objective resolutions. And this idea basically that when the Supreme Court of Pakistan and the judges of the Supreme Court of Pakistan in Asma Jilani's case, they incorporated the objective resolution, then obviously all the courts in Pakistan and obviously the high courts of Pakistan gave numerous judgments and the new era started. Justice Sajjad Ahmed in that case basically, he gave the concept that if the objective resolution is just not a preface, but the spirit and fundamental norm of the constitutional concept of Pakistan, then obviously there was a shift in the judicial pronouncement, and then came the Ziaur Rahman case. Ziaur Rahman case, that was Justice Ziaur Rahman case, that was against Yahya Khan's martial law, and during that Yahya Khan's martial law, some people were sentenced under the martial law regulations. So that case came up before the court. I will not go into the history of that case, but in that case, in PLD 1972 Lahore High Court, led by Justice Afzal-Dullah, what they said that Justice Afzal-Dullah interpreted the objective resolution as the supra-constitutional instrument. That was a landmark judgment in which the objective resolution, basically which enshrines the sovereignty of the Allah and the everybody in Pakistan deriving authority from the people of Pakistan derives authority as a sacred trust. So, and everything has to be recognized and interpreted under the doctrines of Islam. So, Afzal-Dullah, that judgment was a landmark judgment. But ultimately, that judgment came before the Supreme Court of Pakistan. And the Justice Hamood Rahman himself, who previously recognized that objective resolution is the ground norm of Pakistan, he took a somersault, or you can say he interpreted it in some other manner. And in that case, the judiciary said that no, the objective resolution is there, but it is not the supra-constitutional instrument, because now 1973 constitution has been promulgated. And when there is a written constitution, then you have to follow the written constitution. And the written constitution of Pakistan, basically, what was in that written constitution, and still that available. Obviously, at that time, there were no federal Shariah court, no federal Shariah appellate bench of the Supreme Court of Pakistan. The only two provisions which existed under the title of Islamic provision, that no law shall be made which is repugnant to the injunction of Holy Quran and Sunnah. So the interpretation by the Supreme Court of Pakistan was that yes, if you want to recourse for the Islamization of the law, then you have to go to the Parliament, and the Supreme Court of Pakistan is not the proper forum for education under that was the Ziaur Rahman case. Then obviously the Nusrat Bhutto case came, PLD 77, Supreme Court 657, and in that case, before the court, there were two options. One was the doctrine of necessity, and that was the martial law era. And now the court had to legitimize the martial law. Nusrat Bhutto case was there. So, but there were two theories. One was to done away the martial law was the Asma Jilani's case. Because when there is no constitution, try to understand this very important phenomena. What the Sharia law has done and the objective resolution has done in Pakistan. There was a complete vacuum. If there is no constitution, there is a vacuum. So the vacuum was filled by the Supreme Court of Pakistan through the aid of objective resolution in Asma Jilani case. So they saved the democracy, and they annulled the what was done by the Yahya Khan by the imposition of martial law. So in Asma Jilani's case, the martial law was held as ultra-virus, ultra-constitutional with the aid of objective resolution. But then, when the Nusrat Bhutto case came, now there was two options. One was Asma Jilani case, and the other was Western doctrine of necessity by the Justice Munir. So they took a middle way. And all the judges of the Supreme Court of Pakistan, in that judgment, what they recognize? They recognize Islam has the ideological foundation of Pakistan. This was the Justice Afzal Chima's, and this was a totally a new way to exist apart from written legal source. Then obviously there came another judgment passed by Justice Gul when there was during the period of Zulfikar Ali Bhutto, National Awami Party was banned in Pakistan. It is Khan Abdul Wali Khan case. And for the restoration of that party in PLD 1976 Supreme Court, Justice Gul of the Supreme Court of Pakistan, he made much emphasis to the doctrine of Do Qaumi Nazariya. Do Qaumi Nazariya. And Do Qaumi Nazariya was utilized, two-nation theory was utilized and incorporated in this Pakistan judicial history to basically ban the National Awami Party because there was allegation that they are acting against the two-nation theory and the very idea and concept of Pakistan. So, there is another era after 72, between the 77 until 2001. This is the era of Islamization of the laws. And the judiciary played a very active role in the Islamization of law during the era 1977 till 2001. And during this period, there are plethora of judgments. You can cite hundreds of judgments in which it has been accepted by the Supreme Court of Pakistan, the Federal Shariah Court of Pakistan, and the obviously high courts that there was the Islamic law was taken as aid, and there was a landmark judgment, and that was followed in many other cases. And it was for the aid of international convention and international treaty, rather a bilateral treaty within the USSR. This was a state judgment A.M. Qureshi versus USSR, PLD 1981, Supreme Court 377. International law doctrine of Islam, Islamic international law was specifically referred to nullify an agreement between the Pakistan and the USSR. So on the basis of Islamic law, in the meantime, you must remember, there was a judgment in Ziaur Rahman case. The Supreme Court of Pakistan has taken the view that the objective resolution is not the part of the constitution. It is just a preamble. So unless and until it is a part of the constitution, it cannot taken as an aid of interpretation or to nullify the laws in Pakistan. Then General Ziaul Haq incorporated Article 2A in the constitution, and the objective resolution was made a substantive part of the constitution. So there was another problem for the judiciary in Pakistan. It was a good or bad, that is something else. But the judiciary in Pakistan, specifically Justice Tanzilur Rahman, Justice Fazlur Rahman, Justice Afzal Zullah, they laid down numerous judgments in different areas and fields. Justice Tanzilur Rahman, while sitting as a judge of the Sindh High Court, he, in a State Bank of Pakistan versus custodian of Evaki Trust case, he basically declared as void while utilizing provision of Article 2A of the Constitution, Section 55 of the Transfer of Property Act. and the mortgage, the banking mortgage, the concept idea that it was based on the interest and usury. So there was number of judgments. On the basis of Article 2A, the Supreme Court of Pakistan, the high courts in Pakistan, and obviously they interpreted the laws in the light of the Sharia and international law. But this was another problematic area. So there came another judgment of the Supreme Court of Pakistan. And in that judgment, the Supreme Court of Pakistan stated Article 2 of the Constitution, this is Mia Aziz A. Sheikh versus Commission of Income Tax, PLD 1989, Supreme Court 6133. And then came the case of Hakim Khan versus Federation of Pakistan, PLD 91, Supreme Court 595, and Kanis Fatma case, PLD